Good morning, Lynette, and to all of the participants here. I first want to confirm if I can be heard. Okay, thank you. And may I also request, Lynette, that you help with sharing my presentation? Somehow it's not coming through on this end. That's the delay. Okay. I think I've got it. Can you see my screen now? Hello? Okay. Thank you so much. Maybe let's see how it goes in the first few minutes. Then let me also uh, switch on my video. Okay. All right. So thank you for the kind invitation to make this contribution to this team of lawyers in Uganda. And I also want to welcome all of you to this important engagement, where I hope that we can learn from each other on critical aspects of how to, better protect those that we serve, those that we care about, in one way or another, from online gender-based violence. So basically, before we go deep into the discussion, I would like to start with uh, call it an icebreaker, and it will be a short video, which I would request that we pay attention to. Ready, on intent. Media aggressive into these corrupt networks led us right into the heart of the administration. Digging into the social circle and media and all of that. Yeah, very good at that, weren't you? How's it going with your source? I'm not going to stop pushing. Reporting it again. I just wish these platforms would take this seriously. Lynette, I heard you say something. You can't see the video that side? Yes. Okay. Uh, okay. Are you able to assist with playing it? Okay. Thank you so much. Sorry. Uh, this is the interface of technology with perhaps basic skills in technology. Okay. Thank you so much. Maybe as we wait for the video to come through, just to really share the context to it, which is really the reality of online gender-based violence, not only really to people that we expect we will be serving, but also really even to ourselves in our line of duty. It's a story of a journalist, and as we're going to see, I think much of it speaks to itself. And then, yes, you can go ahead to play the video. We do not seem to listen to the sound.
Yeah, keep working on that, won't you? How's it going?
Following the media address yesterday, our investigation
Into these corrupt networks led us right into the heart of the administration.
About the digging into the Bonambi social circle and media feeds and all of that.
Yeah, keep working on that, won't you? How's it going with your source?
Collected any intel from Bonambi's office was right at the
I'm not going to stop pushing. The truth is going to come out. I'm reporting it again. I just wish these platforms would take this seriously.
My favorite is Thai.
No, I can't do a favorite, guys. It's always like a different case, basically.
So, how are you doing?
This needs to stop. You need to go to the police.
Okay, thank you very much, FIDA tech team, for rescuing me. Now, as you can see, really, from the work of that journalist, it is clear that really technology, in many ways, is at crossroads, not only really with the protection of women and children, but also society generally, including in our work, as Harry Alon suggested. And the sad reality also, as another introductory note, is that we sometimes also are, complicit in the perpetration of the violence. When we watch, like, and share content from others in a way that gives in a way that gives prominence to that kind of content, and thereby encouraging perpetrators. And for that point, I have one other video, I hope the last one, to play for you now, which is a 2008 film. This is the thriller. The film is called Untraceable, directed by Gregory Hoblit. And again, we see how our innocent attraction to content online that may involve incidents of violence actually go to entrench the perpetration of that violence. I'll now invite again our tech team to play for us that thriller. It's again about 2 minutes. Thank you. Can you hear me, please? Okay, my apologies. There's
even busier night for us.
They can catch any criminal with the touch of a button.
You got him now.
We need you to knock down a door for us.
Move it! Police! The suspect's in custody.
Good work.
Hi, Mommy. Did you need bad guys?
One. Just one.
But nothing prepared them for this.
Check out this tip we got about our website. Is this real?
It's streaming live.
Just when you thought you'd seen it all. Do you see that box? It regulates the amount of fluid going into the victim. So the more people visit the site, the faster he bleeds.
That's right.
This website's like nothing we've ever seen before.
It's untraceable. The public are tuning in at an alarming rate.
This guy can invite the whole world to help him kill anybody he wants, and there's not a damn thing we can do about it.
Oh my God.
The second victim has appeared on the site. Set up a press conference.
This is just what he wants. Anything you say will only promote the site and kill him faster.
I got no choice. The torture that he is experiencing is unimaginable in its cruelty. Any American who visits the site is an accomplice to murder. Stay away from the site. We are the murder weapon.
He died in 20 minutes. The next one will die in the blink of an eye.
The closer they get to finding him,
Please open the door. It's the wrong house. He knew we were coming.
the closer he'll be to finding her.
There is a connection, and he knows that you're leading the team to find out what it is.
I'm running the trace now.
Here's my credit card number.
He got all the way into my wireless network, which means he can see every single keystroke.
Mom, there's a video of our house on the computer.
You know whose car this is?
Yeah, I think I have an idea.
What if you never catch him?
This is bad.
You think this is it? It's just the beginning.
Diane Lane,
He hacked into my car's computer?
Hello, Jennifer.
Okay, and that's it for some of the icebreakers. I hope we have picked some insights from them. As legal professionals, we really need to instrumentalize our legal knowledge and advocacy skills to bulwark society from all forms of violence. And I think those two videos, if anything, do speak to that reality. Now, of course, you saw the call, and your interest in participating perhaps speaks to some greater degree of involvement in work around gender-based violence, but also really generally the work of FIDA-Uganda. And so the training is part of the efforts by FIDA-Uganda, as I understand it, to create awareness and enhance protection of those who are likely to be targeted and by gender-based violence. And as part of those efforts, in 2023, there's a study that was conducted by FIDA-Uganda, which I was a lead researcher. And that study involved an analysis of the legal and policy framework of Uganda to test the extent to which they were effective in protecting against online gender-based violence. Briefly, it involved a mass online survey where we're picking insights from participants from across the divide on critical issues around gender-based violence online. But also, in addition to that online survey, we reviewed developments in popular culture and online interactions, and we interviewed stakeholders, users of online platforms, law enforcement personnel, those in the civil society, and also a judicial officer and lawyers. And so this training is a continuation of the findings in that study, partly as a sharing of information, but also really then to speak to that important aspect of legal protection, which can best be done by lawyers and those that are involved in the justice system in one way or another. And this is because one of the recommendations in that report, which I hope is accessible on FIDA's website, was to raise awareness on online gender-based violence in Uganda, but also about the regulatory framework in force and ensuring the enforcement of that framework, while also pushing for reforms as relevant. So sometime last year, as FIDA was conceptualizing this training we are having today, I received some instructions which were in the form of objectives that I should contribute to achievement. And like Lynette indicated, we hope that by the end of this training, and as you may have seen in the pre-evaluation, pre-training survey, we hope that you can have a better understanding of the current legal landscape in Uganda relating to protection against online gender-based violence, including some of these, critical provisions, but also then in a much later discussion, what we may or we will show as the shortcomings in that framework, and also to highlight the opportunities for reform, with a view then to designing a strategy together to push for those reforms to be implemented or developed with a view to better protection of those subject to GBV online. So the overarching then objective is for you to be well equipped to protect victims through your legal practice. But maybe before we go ahead, we've mentioned GBV online gender-based violence as well. I would like to hear some understandings of these two terminologies before we can proceed further. So I invite some contributions from you on what you understand by these terms. You are welcome to raise a hand and to then make your contribution. Do we have some contributions on the understanding of these terminologies? Yes, I can see Elizabeth and Abishaga in that order.
Good morning, everyone. Can first meet? So for my understanding of the online GBV, this is violence perpetrated in the online space. By then, necessarily have to be just on social media, but violence that is perpetrated using technologically facilitated means. It could be phones, it could be computers, laptops, anything related to technology, though it most commonly happens online, and that's where the contention is. Then gender-based violence, this is violence perpetrated against somebody based on your gender. So I'm going to harm you because you're a woman, or because you're a man, or because you're the other gender. But basically, that is it. My understanding. Thank you.
Yes, thank you, Abhishek. I think somebody called Elizabeth. Okay, thank you for that contribution, Abhishek. And it is really pretty much what you have said. Gender-based violence is that form of violence subjected to a person based on their gender. It can be sexual, physical, verbal, psychological, emotional, socioeconomic, and really many forms. Some of the other, this can be verbal violence, hate speech on the internet, threats to rape or murder, among others. Now, initially, and as we show in that report we prepared together with FIDA last year, gender-based violence was understood in narrow terms, which suggested that it only targeted women. So you will find in a number of instruments and also policy documents a somewhat consistent reference to the term violence against women, or as some of other variants show, gender-based violence against women. And in that regard, you can look at Article 1 of the UN Declaration on the Elimination of Violence Against Women, Article 3 of the Council of Europe's Convention on Preventing and Combating Violence Against Women and Domestic Violence, which is popularly known as the Istanbul Convention. But also back closer to home, in respect to the African human rights system, that preamble to the Protocol to the African Charter on the rights of women in Africa, the Maputo Protocol, which again reiterates the call by previous documents, the Dakar Declaration and the Beijing Platform for Action, calling on states to take concrete steps to give greater attention to human rights of women in order to eliminate all forms of discrimination and of gender-based violence against women. And of course, then they give the different understandings of violence against women. So, but it can be broader, and it is indeed broader. And it is now almost universally accepted that gender really surpasses that traditional binary categorization of male and female, right? So you can have other broader, understandings of gender-based violence, persons with disabilities, and a number of other really facets of gender. But even within the traditional binary view of gender, we know that sometimes actually men can also be targeted, or even other groups, and have been targeted. So it is not necessarily very accurate that gender-based violence affects only women. So, and as one of the efforts to clarify that, we can refer to the Council of Europe, which in its manual on gender matters, a manual on addressing gender-based violence affecting young people, has provided a starting point for a working definition for GBV as any type of harm that is perpetrated against a person or group of people because of their factual or perceived, and again, a number of categories there: sex, gender, sexual orientation, and gender identity. Definitely in our context as Uganda, there are few understandings that are still questionable. For instance, sexual orientation, in light of the recent legal developments. But really just to provide us with that broad understanding at that level. And of course, as Abig Shag has stated, then when those kinds of violence targeted at specific groups of people simply for who they are, if they happen online, then we come up with what is known as online gender-based violence. And this manifests in all of these different acts that I list there: cyberbullying, surveillance, stalking, doxing, sexual harassment, for instance, unsolicited, sexual messages, non-consensual exposure of nude images, hate speech, impersonation, even unauthorized access to gadgets, a point that I think has been made most strongly in the African Human Rights Declaration on freedom of expression and access to information in Africa, and the one on protection of women from online gender-based violence, as we shall see shortly. Now, there are, of course, enduring trends which perhaps reinforce the initial understanding of gender-based violence, that those of women being more at the receiving end of these kinds of violence, even in the online spaces, right? But we also need to understand that, yes, while online gender-based violence happen, but also the digital platforms or the online space also in a number of ways facilitates actually protection and responses to violence against women and other targeted gender. So it can be used as a tool to fight GBV, for instance, where you have, gadgets, for instance, that are programmed to protect people by, for instance, pressing a button, which then communicates a message to maybe law enforcement or caretakers to come and rescue one in the event that they are targeted. You saw during COVID what happened, where some of the services, say legal aid, pro bono services, and some even medical information was provided through the use of digital platforms. So it is not all bad with the usage of online platforms, but we have to again be responsive and effectively so to those negative developments that are associated with our existence online. Now, where do we stand as a country in terms of our digital landscape? Our findings in that report of 2023 confirm that internet penetration in Uganda is still low, although it is steadily growing. We had about 4 million users in 2012. That has since risen by about 3 times to close to 14 million in 2022. But still, that is less than 30% of the population. So, yes, a growth, but not yet convincing growth. And there are still challenges of access to internet, for instance. Devices are still scantily supplied. 49% of the population had mobile phones, according to a survey by After Access in 2018. This rose to 57.9% as of the 2022 data report or assessment. So we have a digital gender gap, as well. Mostly urban and urban dwellers, and also among those male, have a dominant access to devices and therefore use them. And so in the statistics on our online activity as a country, generally, some of the data that we came across show that actually say most of the searches are your traditional male obsessions, football betting, sports betting. Those are some of the sites that are most visited, live scores. So, and we ask whether then the perceptible dominance of men online then also translates into them being mostly the perpetrators of online gender-based violence, which actually appears to be the case. All right. Again, as a country, there is limited knowledge and skills for uptake of internet. That's one of the challenges contributing to the slow penetration and the digital gender gap. We have, in some places, especially in the rural areas, where there is literally no coverage, although again that is changing. And our internet uses, like I've said, some of it is on gaming, but also socializing, WhatsApp, Twitter, TikTok, sharing updates about one's personal or life information, generally searching for information on different things. But also, again, mostly during COVID, we used the internet, I think, much more for educational purposes, to learn about, for instance, COVID, but also for those of us who had either educational programs running or for our family members, maybe children, siblings. Again, there was that rise in the use of the online platforms for educational purposes, even to as low levels as primary school, even nursery, but also really the platforms are used for business and communication. And to situate that within the broader framework of the country trends, we know that at the national level, the government at least has communicated to be committed to developing a digital vision for Uganda with a view to building a digitally enabled society that is secure, sustainable, innovative, transformative, that all being intended to create a positive social and economic impact on the country through technology-based empowerment. But of course, at the micro level, we note that some of the recourse to digital communications by citizens is actually a cost-effective measure, strategy, to substitute for the costly, voice and text services over the traditional, traditional communication platforms. So social media platforms, TikTok, Instagram, Twitter and WhatsApp are being used more for making calls. You're not charged per minute as long as you still have data, but also really then to text, and also they are fast. So at the micro level, much of the usage is yet to really fit in quite neatly with the aspirations at the macro level. Like I said, during COVID, the usage of internet at the grassroots, of course, then rose through the roof because of different reasons. They need to access services, education, but also health information, related information, and also the virtual work environment and demand necessitated that we become more involved with the online platforms. And of course, then the exposure to the risks, right? I also mentioned some innovations, including by FIDA, to again now enhance protection of especially marginalized communities while they are engaging online. Now, these contexts are important for us to understand then what is the most important task for us, which is offering legal advice, but also protection of our clients, those who come to us to seek for services of different forms. So, but we go into before we go into the framework, the legal, protection at the national frameworks guide on the rights that are associated with our online existence. So they are, if you like, really the standard setters then. And when then you're able to know the contours within which it is legal or illegal, within which it's acceptable, justifiable, and reasonable to regulate online activity, but also to protect those involved in online spaces, then you can have a framework that is sensitive, including to the gender aspects. All right. So, of course, different rights protected under research shows the attacks or the violence emitted at such women is intended then to keep them in the backyard, to take them back to the traditional patriarchal understanding of the role of women, which is to be housewives, to be, the voiceless, to just heed to whatever forms of pressure come their way without stating or even making their voice known, and especially to contribute positively to society. The test of our laws and policies on GBV have to meet, under those instruments at the international and regional level, whether by way of conviction, say, where we have ratified some of these instruments as we have, actually most of them, or simply because really they are the best guidance to the best form of protection for our justice seekers. And so when we advocate for reforms, we often have to go and look at these instruments and see the best practices, all right? And as we shall be looking through the legal framework at the national level, we shall ask ourselves then the extent to which then those laws and policies at the domestic level reflect what have been devolved or proposed as the best practices in regards to protection of online users, particularly those that are likely to suffer from or to be targeted by a gender-based violence. And of course, we know I've mentioned the other rights, and it has been made clear, at least as of 2018, with that report of the UN Special Rapporteur on the causes and consequences of online violence against women, that even though the core international human rights instruments, those that preceded, the digital evolution, even though, they were drafted before the advent of ICTs, they still provide a global and dynamic set of rights and obligations. And they therefore have transformative potential and have a key role to play in the promotion and protection of fundamental rights. Fundamental rights including the right to live a life that is free from violence, the freedom of expression, like we have stated, privacy, access to information, including that information that is then shared through ICTs. Of course, we know that information now is much more easily accessible online. And if it's not safe for a woman or any other gender category to access that information online, then we simply are impeding their enjoyment of those critical rights that are also central to their own existence, right? And that report's view was really simply a reiteration of some early observations, for instance, made by the Human Rights Committee in its resolution 3213. Okay, now as a build on, in 2022, again, there was a joint declaration on freedom of expression and gender justice, which importantly affirmed the issue that, the same level of protection has to be accorded to all rights and all people, both online and offline, right? So that joint declaration has a number of recommendations to states, which I look at as best practices and standards that then our domestic frameworks, laws, and policies need to meet. It outlines a number of standards that are, critical for ensuring gender equality and safety, both online and offline. It also recommends, importantly, that we must prohibit sex and gender-based violence online, including incitement to discrimination, hostility, or violence. And we should also prohibit misogyny that goes beyond the threshold of what is justifiable, reasonable, and acceptable in a free and democratic society, right? And it also affirms the need for a whole of society approach, which involves states, private sector, and civil society in promoting equality and removing barriers to freedom of expression and gender justice online. So that interpretive joint declaration cites a number of obligations for states as part of the whole of society approach. So in respect to the states, the duties are several. And one of these is ensuring to adopt measures, that guarantee safety in online platforms, but also to ensure that women and other gender minorities participate effectively in online platforms. And what does that call for? Strong data protection regulations. Question is, do we have those in Uganda? It also calls for, development of regulations that enhance transparency, due process, and human rights due diligence of companies that provide internet services or the digital communication technologies. Of course, women, then children, the specific one issued by the United Nations Committee on the Right of the Child, which is General Comment number 25, which was adopted in 2021, specifically on the rights of children in relation to the digital environment, right? Again, calling on states to promote children's participation in digital platforms, but doing that side by side with ensuring that, again, children's online presence does not subject them to harmful content. All right. So that's in respect to some of the measures generally. In specific terms, the declaration again calls on states to enact specific legislation, and where there is some form of legislation that is existing but not yet up to the task, to have that legislation updated. And this legislation, whether new or updated, should prohibit, investigate, provide for investigation and prosecution of online sexual and gender-based violence. Again, those being done in line with the relevant human rights standards that those states have, ratified or in one way or another agreed to be bound by. Okay, states also have a duty to train law enforcement officials and support services to recognize and respond to the distinct gendered nature of online violence, and that, and a heightened risk of violence arising from them. So law enforcement officials and those who are supporting provision of services, justice services specifically, need to be able to, make sense of gender-based violence-related laws in respect to the online sphere. But important, we have to ensure participation. In other words, for the reforms or even the enactment of laws to be effective, the people who are the ultimate beneficiaries of these laws or policies have to be involved. Okay, so when policies, laws, treaties, community standards, technology and regulations are being discussed, designed, or adopted, the ultimate beneficiaries of those have to be, as a matter of recommendation to states by the joint declaration, they have to be involved. Participation is key. Consultation and therefore contribution of what they feel to be the most critical aspects to be addressed by legislation, regulatory frameworks, in other words. So again, as part of the whole of society approach, there are obligations that are expected to be met by private actors. And in this case, for the internet intermediaries, they have a duty to undertake regular human rights and gender impact assessments, those being done to identify and mitigate the risk of how the business models of these intermediaries, their user engagement practices, their advertising programs, their targeting, again, initiatives and profiling practices of their users, and how, their content moderation and curation, data collection, and privacy practices. These have to be assessed on how they impact on human rights of users online, but also importantly, in light of those impacts identified, to adopt mitigation strategies to, eliminate, or at least to the greatest extent, do away with risks. Okay. Also, intermediaries have a duty to develop and enable secure digital communications, including, providing for strong encryption and anonymity enhancing tools, but also generally ensuring secure products and services. This they should do. And therefore, we expect that in the laws and policies that we have at the national level, these critical aspects are catered for as well, so that then it's a matter of law that then can be enforced through the different mechanisms for purposes of protecting users. Okay. But also, in respect to the end users, they have to be empowered. So the declaration recommends for the intermediaries, internet intermediaries, to empower groups such as women, and I quote, empower them with the means to protect their privacy and security, with the means to control what data is collected from them, and also to determine and agree to whom it is distributed and how and in what ways then that data should be distributed and received. Okay. But also specifically ensure that they are protected from violence and hatred. Of course, then there is a duty to the intermediaries to make their policies on discrimination, non-discrimination, gender equality, and safety from online known publicly by availing them and explaining their practices and decision-making processes to the public, so that people know and make an informed decision as to whether or not they want to engage with those intermediaries, or to, again, for purposes of their protection, to maybe keep a distance, right? So in the course of the discussion, we shall be looking at how then our domestic laws and policies reflect these standards and recommendations. Maybe before I proceed to the Africa-specific frameworks, I wonder if there are, at this point, some questions that that you want to raise. Do you have some questions? Okay, probably not. So let's now go to some of the other reinforcing frameworks that have been developed at the Africa regional level, again, through mainly the African Commission on Human and People's Rights. Like I said, some of these are soft law instruments, but they are useful guidance points. They are best practices that we need to embrace for us to ensure that our laws and practices, but also our interpretation of those laws and practices and policies and our enforcement of the same, then facilitates a meaningful realization of the rights protected online and offline. So from the African regional framework, I would like to draw your attention to the Declaration of Principles on Freedom of Expression and Access to Information in Africa. This was adopted in 2019 during the 65th Ordinary Session of the African Commission on Human and People's Rights. Now, like I mentioned earlier, this instrument specifically responds to newer challenges presented by ICTs by outlining several principles that are relevant to the usage and safety online. Of course, it stresses the right of everyone to privacy, including the confidentiality of one's communications and the right to protect one's personal information online. Right? That's in Principle 40, Paragraph 1, Principle 40, Paragraph 2. You have a right, all your clients have a right to communicate anonymously, including use of pseudonyms on the internet. You have a right to secure your confidentiality of the confidentiality of your communications, and also confidentiality of your personal information from being accessed by third parties. Then also, states are prohibited from adopting laws or other measures that, make it criminalize, if you like, which in their phrasing is prohibiting or weakening encryption. For instance, backdoors, key escrows, and data localization requirements. Okay, so the state can only prohibit those to the extent that their inroad is justifiable and compatible with international human rights laws and standards. So it, in a sense, does away with dictatorial tendencies, where again regulation of internet platforms and engagement is intended for nothing that is justifiable and reasonable, but rather to either stifle or to impose undue inconvenience to those that are using the platforms. So specifically, states have a number of duties under the declaration in respect to protecting and ensuring enjoyment of your rights or your safety online, right? And the first is to introduce legally based penal sanctions against the harmful sharing of personal information, child sexual abuse, non-consensual sharing of intimate images, which I think is a very, very unfortunate, dominant a form of violation, gender-based violation in our context as a country. There are times even you see people on social media calling out, months and say, allotting months, this month is for so and so. because their nudes were leaked, right? So they even kind of look at it as a playful, as a form of entertainment that, today it is X person, the other month is going to be so and so, now we expect so and so. And but this is because this information is shared. So states have a duty to impose penal sanctions against the harmful sharing of personal information, including those intimate images of some of those people that are shared. And we have seen over the years since, I think mostly around the 2010s and on. All right. But also, it is upon states to ensure, that those persons, when their rights or safety generally is compromised online or totally outdone, they have access to legal recourse. They can seek recourse before the courts of law through other mechanisms, and that the remedies are available, not just remedies, but effective remedies, for violation of privacy and unlawful access and processing of personal information. Again, as a matter of law, states are required to put in place independent entities that should oversee the protection of communication and personal information online. Okay. Then to take measures to address the needs of gender minorities, to enable them to fully enjoy their rights to freedom of expression, access to information on an equal basis with others. And also, they must require internet intermediaries to mainstream human rights safeguards into their processes. Like we have seen, of course, the duties of internet intermediaries as part of the private players in the whole of society approach. But then states are required to also specifically have it as a requirement for these intermediaries, so that it's not just gratuitous, but a duty that is expected to be met by the state as the ultimate guarantor of protection for its citizens through that social contract that we renew every, in our case, 5 years at the ballot, and then trust the leaders to steward us to safety and to development in different facets of life. Okay. So also, law enforcement agencies have, to be mandated to, engage with those intermediaries to request for instance, expedited or immediate removal of online content that poses imminent danger or constitutes real risk, for instance, of death or serious harm to a person or child. Again, making room for, safeguards against arbitrariness. So there's need for, again, a judicial review process before that is, is done by the law enforcement agencies, to order intermediaries. So they can only order that through a judicious process to guard against authoritarian tendencies that we know happen in some countries, and so that's also quite important for us to note. Of course, we have mentioned women, we have mentioned gender minorities, but I know that also part of our interests today is to understand also the specific protection of children. And so I thought it was important to, again, emphasize these points from the Declaration on Freedom of Expression and Access to Information in Africa on, the protection of children, right? So States have duties in that regard, including number one, recognizing and respecting the evolving capacities of children and adolescents in the course of their policy development. So states have to ensure that they adopt measures that enable children to effectively receive, express, and disseminate information, taking primary consideration of the best interests of the child. Okay, but also then to adopt laws, policies, and other measures to promote access to affordable internet that equips children with digital literacy skills for them to be able to engage online for maybe education purposes, but also to ensure that they are safe and that they are protected from harm that may arise online, and that their safety their privacy and identity is safeguarded. So that is it from the declaration. But also in 2022, one commission adopted a resolution, which I think is the most recent, and particularly more so in respect to gender-based violence, right? So that resolution on the protection of women against digital violence in Africa emphasizes the urgent need to review legislative frameworks. Why? To weed out discriminatory laws that exacerbate violence against women. And why should that be done? Because women need to be afforded better protection from online violence, and those that are culpable have to be penalized. So they have to be criminal sanctions against those who perpetrate digital violence against women under the domestic national laws. Okay, and as part of that, states are required to, number one, revise, for instance, their definition of gender-based violence to include online violence against women. Okay, so where we see a legal provision reading, gender-based violence, prevention and enforcement, then you can read into, or we should read in, online violence against women, right? So they also are required to equip practitioners and professionals dealing with online gender-based violence, this including law enforcement authorities, social and child health care staff, but also criminal justice actors and members of the judiciary. These need to be equipped with up-to-date skills, and that being achieved through mandatory and continuous training. Of course, I think then through the support of stakeholders like FIDA-Uganda, I don't know if we have some such personnel as lawyers in their professional capacity on this platform, but I understand that they are, for instance, been involved in the validation processes. I remember we had, I think, somebody from the Ministry of Gender last year, the validation. But we can also really appreciate then the platform for this continuous training for lawyers, because also they are the ones that then go to these law enforcement and judicial mechanisms to interpret rights, to seek to defend those that have been affected. And so it is a useful, really, initiative that then this knowledge is shared across the board, so that then while the lawyers are already in the process of getting to, enhance their capacities in respect to online gender-based violence protection strategies and tools, it's important that also the officers that they go to seek for enforcement are also equally, sensitized on the tools, but also how to proactively ensure gender justice, even in those situations where it is not immediately clear from the laws and policies or required specifically, but for the sake of justice and as part of the movement, to ensure that they read in relevantly and in light, particularly, of our international commitments and best practices. Now, states also have a responsibility to facilitate cooperation between law enforcement and internet service providers for purposes of identifying perpetrators of online violence against women. Again, you have seen this coming through in the Declaration on Freedom of Expression and Access to Information in Africa. And finally, is to implement victim-friendly and gender-sensitive policies when handling cases of online violence against women. Of course, as you've seen some of the experiences in our country, as we shall be discussing in the next 1-2 hours, sometimes there is a challenge where, for instance, a case is brought to court, but because of the manner in which it is handled or some of the procedures that are relevant for, say, securing a conviction, where those are in a way gender insensitive, and perhaps ending up collapsing because maybe the victim or survivor, we have to also be careful with the terminologies we use, where the survivor, for instance, feels that continuing to participate in a process that is purported to be one leading to their justice is actually an extension of their violation. So they opt out, and then justice is not served. All right. But then we need to remember that states actually should and have been recommended to implement victim-friendly and gender-sensitive policies when handling cases of violence against gender minorities, that is perpetrated online. And so briefly, in terms of the key takeaways from the international and regional standard setting frameworks, of course, this is a non-exhaustive list. We know for sure that the same level of protection against gender-based violence in the physical spaces also applies in respect to the offline spaces, rather in respect to the online platforms in the digital sphere. All right. Gender equality and safety online are key as part of the continuation of the human and other safety, human rights and other safety considerations that are often, prioritized in the physical space. Number two, we have seen the frameworks making a specific requirement for explicit mentioning of sex and gender as elements of some of the, say, offenses or crimes in domestic legislations, for instance, hate crimes. All right. We have also noted the recommendation for a whole of society approach in promoting freedom of expression and access to information online. Right. Then also the emphasis on safety and participation of marginalized groups, through strong data protection regulations, transparency, etc. All right. Then the duty of states to prohibit, investigate, and prosecute online sexual and gender-based violence, including prohibition of misogyny, but also the duty to train law enforcement officials and support services to be able to handle in a gender-sensitive manner the cases of violation when brought before them, but also a particular emphasis on protection of children online. We shall have some further discussion on this later in the context of how then do we ensure adequate protection for children. There are also other emerging, discussions around, for instance, to what extent do you go in adopting protective measures against violence for children, in light of their evolving capacities, but also the fact that at times, children are also, of course, yes, as part of the evolving capacities, they are growing and also using the online platforms to explore some of aspects of their lives, for instance, sexuality. So how do you strike a balance between the urgent need for protection, but also really, again, not being that intrusive unnecessarily and disruptive, if you like, really, in the natural growth and life course growth of a person, so that then their ultimate outlook as adults becomes a composition of their experiences and exposure, and they have been able to explore their life, spiritually, academically through schools, but also, for instance, sexually um, over the years. So how do you balance the need to protection and some of these again realities of evolving capacities? We have also seen specific responsibilities on private actors, based on the guiding principles issued by the UN in respect to business and human rights, but also private actors being required to undertake human rights and gender impact assessments to identify, assess, and mitigate potential harm from their operations. The duty to report, to inform the public of policies and procedures, for instance, in respect to complaints, how simple are their procedures, how fast do they go, and are they culturally relevant to address, the issues that relate to online gender-based violence in a non-particular context, all right? So that is it from the international and regional framework. So really, this first hour, or not yet an hour actually, has been an attempt for us to, first of all, look at the issue from the point of view of what an ideal legal or policy framework at a domestic level should look like. Then with that insight, we should then be able to look into our domestic laws and policies and see their fitness for purpose, for the purposes that have been stipulated under those frameworks that we have just discussed now. And also to identify then where there are needs, say, for reform, what those reforms are, and in the pendency of those reforms, look at some of the opportunities within the existing frameworks to see how we can, in the meantime, ensure a protection against online gender-based violence. All right? And I think this is the point now at which I invite again reflections from the participants on what we have so far shared. Please feel free to raise your hand and make a contribution. Of course, I see now that I think I don't have any hands raised yet. So you are welcome to unmute yourself and just speak, since there is no queue at the moment.
Hello. Good morning.
Good morning, Susan.
Yes, thank you very much for your presentation. However, I have a question regarding the online gender-based violence, especially from the angle of feminism or the angle of the work that FIDA-Uganda does, whereby most of the time it happens after certain instances. For example, some might not come and write about me necessarily when they don't know me. They are more in revenge settings, if I should say. Like someone did this, then I used to come and do this on social media about that person. So when you investigate the cases further, most times you find that there was an instigation from the victim. Probably someone instigated that violence. But also we understand that from the work we do or from our world as feminists, we can't have what we call victim blaming. There's always something that we need to protect the people. So I don't know how you can help us with striking that balance. But also the other issue I wanted to inquire is that we have a lot of online gender-based violence against children. Or people who are born by celebrities. Most times they post their pictures or videos. It could be out of well intention as a parent. However, the harassment that comes from the media after them putting those pictures or videos is sometimes traumatizing to the children. So I don't know if these are extended to also such kind of worlds, because sometimes they also extend now to IP issues. So I feel like it's a paradigm of things. It's something that I don't know if independent policies will be applicable on that, since we already have laws in place governing this kind of violence, like the Computer Misuse Act and all that. Though these days it's more political, but I don't know how you can guide. Do you think we should have independent policies for this kind of harassments? Given the background that I've given, that most times they are instigated. Thank you.
Okay, thank you, Susan. Susan, I propose we have a couple of feedback, then I respond on the basis of those. So somebody else?
Good morning. It's just simple. I wanted to understand the difference between the intermediaries that you have been talking about and the private actors, if that's possible, to distinguish the two.
Noted.
Good morning. Thank you so much for the presentation. Mine is more, it's an inquiry really. How do we go about cases where a person is in imminent danger or threat because of, someone threatening to expose them or abuse them using technology? Because under normal circumstances, where it comes to physical abuse and a person is under such a threat, they can, file a restraining order or do something about it. But when it comes to the online violence, if someone knows that this violence is going to happen to them and they come to me as a lawyer, how do I help them? Because there is no attempt. The person has not circulated whatever maybe they want to circulate, but they have threatened to do it. How do we go about it? And are there any laws that would aid any action against such a person?
Thank you, Fiona. Do you have some other contributions? Okay, it appears that we don't have some more questions. I would beg to respond now to some of these. Now for Susan, the question on where the victim, who I prefer to call a survivor of online gender-based violence, happens to have instigated. I wasn't very clear as to, how they instigate then or trigger a reaction that is then one of gender-based violence online, right? Because, well, it's I think akin to a situation where you say have somebody commit an offense and also respond by committing an offense. All right. So within the legal framework, as we're going to see at the in the next session, we're going to see that also threats of violence or really I mean, in simple terms, you cannot simply justify commission of an offense because you were also initially affected by the person, by your target. All right. So there are processes, systems in place to respond to all sorts of complaints. All right. And anything that is not legal then cannot be accepted. I think that would be the simple response to that. That I don't see a situation where then a victim of gender-based violence would be denied justice simply because the other person maybe raises a defense of provocation. I don't see gender-based violence being provoked. It is violence for what it is. In respect of children and their caretakers or parents who then put them in the limelight and are exposed to violence, I think it's a question of really what the best interest of the child is, and we already have frameworks that speak to that. Maybe to say that then, say if the handling of this child or the child is violated on the basis of them being in online spaces, principally by the actions of their parents, if that turns out to be a question, say, of negligence or irresponsible parenting, then I believe that's something that can be handled within the framework on children. are the best interests of the child being guaranteed with this kind of approach? And if not, then we can proceed, say, with the probation, and welfare officers, and to see to it that then the government frameworks for regulating or for protection of children then intervene to hail in on the parent or caretaker that is then violating the right of the child. It could be, say, the same thing with things like corporal punishment, those other aspects of violence against children that happen in the physical spaces. So, like I said, the rights that apply in the physical spaces also apply online. Difference between intermediaries and private actors, I'm not sure I see a big difference, because really internet intermediaries are private actors. All right, they simply are, those service providers who facilitate our use of the internet, right? Internet service providers, search engines, and you have quite a number of them, e-commerce intermediaries, say those who sell goods, internet payment systems, among others. So they are really also within the broader framework of private actors. And Fiona, threats, the question of threats and how you address them, I think let's just handle that in the course of the next discussion around the protection under the legal framework at the national level. We shall see that even threats of violence are actually, criminal and can be approached as such. Okay, I hope that helped in one way to clarify on some of the issues that were arose through the feedback that you have shared. So now, where do we stand as a country in light of the test that has been, set under the international and regional frameworks? Okay, and so Uganda's regulation of gender-based violence and online gender-based violence is spread between different tools, of course, like it is the case also for the international level, all right? And it has been evolving over time. Yes, Lynette. Okay, I beg your pardon on the time for the break. 30 minutes. Okay, that's not a problem. Thank you. And yes, I think that's acceptable. Yes, thank you, Lynette, and welcome back, everyone, from the break. I hope that you are now ready for the next session. So, like I was saying before we broke off, that Uganda's regulatory framework for addressing gender-based violence generally has been evolving over time, and so is that in respect to online gender-based violence. In fact, the most accurate way to put it is that actually the framework on online gender-based violence is in its nascent stages. As we are going to see, there are a number of challenges, but also several opportunities for reform and for maximizing the framework as it is to achieve justice. And that's what we're going to look at for now. Now, in respect to gender-based violence generally, we have in place a number of measures, including policies, programs, and plans of action that are designed to promote gender equality and eliminate discrimination, especially against women. Okay, and those of you who follow the international trends, in 2010, Uganda was up for review by the United Nations a CEDAW committee. That committee that monitors implementation of the Convention on Elimination of Discrimination Against Women. And in the concluding observations that the committee made in respect to the Ugandan situation, it appears that the measures are adopted up to that stage were satisfactory, right? But even then, they were satisfactory to a great extent. There were a number of challenges that the committee noted, including, an endurance of limited knowledge by the rights holders, of their rights, but also importantly of the concept of gender equality. Both the rights holders, like I said, but also really also some of the government officials, including the law enforcement, did not have that firm understanding of gender equality. There are also some gaps in the institutional capacity of the Ministry of Gender, Labour and Social Development, and other critical institutions, right? So that conclusion, yes, was limited to violence against women, because that is what CEDAW's mandate is, women and girls. Covering aspects such as widespread domestic violence. But even then, the observations that committee made highlighted a number of concerns which are relevant for us who are interested in understanding the context of, gender-based violence broadly, but also really then the context for online gender-based violence. And I think part of that context, which is important to note from the very beginning, the fact that there appears to be a kind of legitimization in the society of violence against of women and also other gender minorities, and that culture accompanied by yet another a concern of silence by victims of that violence, but also really an entrenched level of impunity uh, by those who perpetrate that violence against women and the other minorities. So because of the culture of silence, you see that there's an underreporting of cases, so people rarely approach justice institutions. Of course, this is not to downplay the tremendous work of actors like FIDA and those of you in your respective capacities who are involved in sensitizing, but also really helping these survivors to have their cases brought to law enforcement bodies for redress. The other concern relates to corruption in institutions such as the police. You go to file a case, you're charged fees that are not anywhere, stipulated within the law. So services that would ideally be free end up, being subjected to payment, and that, of course, then serves as a barrier to then access to justice, to especially those that are poor. Then a number of the programs in place in respect to gender-based violence, the committee noted that they were not evaluated. There was no effective evaluation of them to know, whether they actually are impactful or not. And of course, generally, the lack of social support services such as shelters. So those were that is the context within which then that the legal framework we're going to discuss. And I can see, thank you, FIDA, the slide is being shared there. That's the framework within which we need to appreciate, the extent to which the regulatory measures in place can actually deliver on the protection of survivors, but also prevention of gender-based violence, both in the physical spaces but also online. Of course, as you can see, the starting point in any discussion on matters of law and protection, human rights related issues, really, in our context, is always the Constitution. We have a Bill of Rights, right? So, number of rights guaranteed that are relevant for, our online engagement, access to information, freedom of expression. Really, the rights that I mentioned earlier, even within the international frameworks, are also reflected in the Constitution, recognized. And I think what is even more important is that provision in Article 32, which commits the state of Uganda to, take affirmative action in favor of groups marginalized on the basis of gender, age, disability, of course, any other reasons, created by history, tradition, or custom. And as you saw from the standards we discussed earlier in the first part of the presentation, the enjoyment of human rights or the protected, standards applies both online and offline. So again, after looking at the Constitution, then you go to the secondary level, which is the statutes or acts of Parliament. That hierarchy of laws, I think, is best understood by you, the lawyers who apply it. And so, in respect to gender-based violence, again, you have statutory enactments such as the Domestic Violence Act of 2010. I also have some useful provisions in the Penal Code Act, the Children's Act, the Prevention of Trafficking in Persons Act, a number of them, right? Then there are policies, the National Gender Policy 2007, the Action Plan on Women 2017. Also have a policy on elimination of gender-based violence for Uganda, among others, including actually the National Development Plan 3, as it were. But for purposes of our discussion, we mostly look at the Domestic Violence Act for, I think, two reasons. The first is because it directly relates to aspects of online gender-based violence, but also because it references the rights issues of persons that are focused on by the other instruments, So we would ideally expect the Domestic Violence Act then to respond to online gender-based violence, right? For example, Section 4 of that Domestic Violence Act prohibits domestic violence, right? That prohibition is explicit in Section 4 of the Domestic Violence Act. And domestic violence is defined in Section 2 of that Act as an act or omission of the perpetrator which does or intends to do any of the following. Number one is harm, injure, or endanger the health, safety, life, limb, or the physical and mental well-being of another in a domestic setting, which may include physical abuse, sexual abuse, emotional, verbal, and psychological and economic abuse. But also it can be an act or omission that harasses, harms, injures, or endangers the victim, that being done to coerce them, to meet any unlawful demand, say for property or valuable security. It can be an act or omission that has the effect of threatening the victim or any person related to them by any of their aforesaid conduct, but also, I think, important for online engagement, an act or omission that otherwise injures or causes harm, whether physical or mental, to the victim. So that is paragraph D. And my reading is that paragraph D then suggests that the Domestic Violence Act allows for inclusion of other possibilities which can be creatively interpreted to accommodate online gender-based violence. Of course, we cannot just leave it to guess, all right? It is that would be risky. So I think it is a matter that needs to be solved by having OGBV specifically as stated as one of the other acts or omissions that then can tantamount to a domestic violence, right? And for perspective, we can look at, for instance, the definition of harassment in that act, as conduct, that includes, for instance, repeatedly making abusive telephone calls or causing another person to make abusive telephone calls to the victim, whether or not a conversation ensues, repeatedly sending, delivering, or causing the delivery of offensive or abusive telegrams, fast smiles, electronic mail, telephone, text messages, or similar objects to the victim. That's in section 2, the definition of harassment. Now, that definition, of course, leaves out aspects which, if included, would contribute towards greater protection from online gender-based violence. One of the things that is not included but is important is gender or sex and misogyny as or among the grounds, which can then be adduced as a basis for conducting of those acts as part of the mens rea, really. Then to specifically say that the harm, injury, or harassment was emitted specifically for purposes of simply because the victim or survivor was of that gender, of that sex, or simply because the perpetrator necessarily is misogynist on the basis of available evidence. Again, maybe as part of my background, I am a lawyer, but who practices research and footnotes, not one of procedure. So matters of evidence and how to adduce it and gather it, and I think within your specialization. So that is one avenue for you to explore, and then creatively reading for better protection of society from online gender-based violence, right? So, well, a case in point is that the definition of harassment does not explicitly mention electronic communication of a sexual nature, especially because such communication may not be easily situated under communication that is abusive or offensive. All right. And I think when you look at the Computer Misuse Amendment Act of 2022, that gap of non-inclusion of sexual material is noted, right? But also, I think the Domestic Violence Act does us a disservice, and this is noted in that report we wrote for FIDA last year. That act kind of does us a disservice in its understanding of harassment as being only communication. Remember, we said the definition, only relates to communication, repeatedly making abusive phone calls or causing another person to make such calls to the victim, whether or not a conversation ensues, repeatedly sending, delivering messages. So it assumes that harassment is only communication. But as we know, there are other forms of violence that would tantamount to harassment, which it leaves out. And of course, as you have seen in the instruments, say at the African human rights, regional level, in respect that the declarations and principles that I shared, right? So other things could tantamount to violence without harassment, without them being actually necessary communication. For instance, digital surveillance. All right. Things like unauthorized access to another's devices. Of course, we know that some of these are addressed in other later laws, as you're going to see. Yeah. So digital surveillance, unauthorized access to another person's devices, or access to their social media and email accounts. Then also sharing another person's intimate and private pictures without their consent, and sharing those with third parties. Those also really can be harmful. And if especially done in a domestic context, then they should be considered harassment that is also domestic violence within the contours of the Domestic Violence Act. That to me would be a more gender sensitive and gender, gendered approach to application and enforcement of the Domestic Violence Act. All right, but because then they are not included, it becomes a little hard. One has to be very creative and strategic on how then they argue their case, in order for them to be brought within the realm of protection and redress mechanisms that are provided for under the Domestic Violence Act. And I think the recommendation we made then, in respect to the Domestic Violence Act shortfalls that I've noted, was for, specifically dedicating, domestic violence online and social media. I mean, a provision that speaks to domestic violence online and on social media as one of the offenses under the Domestic Violence Act. And that we drew inspiration from the South African Domestic Violence Amendment Act of 2022. Like I said, our legal framework is on domestic violence and rather on gender-based violence online is still nascent. So these are some of the opportunities and reform proposals that you can highlight and push for in order for us to better protect victims. Again, I use the word victim carefully, rather survivors of online gender-based violence. Now, beyond the Domestic Violence Act, there's also legal regulation into which you can read gender protection. So that legal regulation that is specific to ICT. Of course, as we know, there are a number of laws that have been enacted by Parliament to regulate ICTs, and there are perhaps as many policies as well. So the major tools that we can speak to in this regard in respect to regulation of ICTs include the Computer Misuse Act, initial of 2011, but we know has been amended in 2022. The Data Protection Act, Protection and Privacy Act of 2019, also its regulations. The Electronics Transactions Act of 2011, the Anti-Pornography Act of 2014. And allow me to take you through quite briefly the key provisions that are relevant or that I think are relevant for regulation of online gender-based violence. Let's begin with that 2011 instrument, which is the Computer Misuse Act. May I request for someone to briefly, tell us what the objective of the Computer Misuse Act is or what it does? You are welcome to raise a hand or to simply unmute and briefly tell us what to share knowledge really on what you know about the Computer Misuse Act.
I think good morning. My name is Elizabeth. I think what the Computer Misuse Act broadly seeks to do is sort of have provisions around the usage of electronic transactions and information systems. So about safety, protections, and perhaps penalty for any offenses that are created under or any offenses that accrue in that space. So broadly, it's an act, I think, that speaks on safety, security, usage of electronic transactions and online spaces generally.
Okay, thank you, Elizabeth, and nice meeting you again. Yes, I've seen somebody also raising a hand. That was D.
Yes. Good morning, Jose. My name is Agnes. Just like what Elizabeth has said, the Computer Misuse Act is supposed to protect the integrity and the security of computer information. We are looking at things like data protection. We are looking at things like cyberbullying. We've seen that case from TikTok that is ongoing, where this boy what insulted the Kabaka, the king of Uganda. Eh?
Yes.
So we are seeing it acting, and we are seeing it in place to do away with cyberbullying and data protection and things like leaking people's nudity, among others. Thank you so much.
Thank you very much, Agnes. Apologies, colleagues. Again, I think it's one of those bad days that technology failed me. My name is Brian Kibirango. The username on my profile there is Brandon Jose, which is really a combination of Kibirango, Brian, and Joseph, which are all my names. But yes, Jose is fine, but not popularly known as a name. So as my name. So I thought I should make that clear so that then I don't appear to be confusing. So yes, pretty much what you've said about the Computer Misuse Act is what it is all about, provide for the safety and security of electronic transactions and information systems, and also prevent their abuse. But I think what is importantly for us and in the context of gender-based violence is that that act criminalizes and defines a number of acts, including harassment. If you go to section 24, offensive communications, again, like Agnes and Elizabeth have mentioned, in section 25, cyber stalking, section 26, child pornography, section 23, and any attempts to commit any of these offenses, section 23 again. Someone initially, I remember somebody who asked about threats, and how you go about them. For instance, of course, we can read some of these things into some of these items of the definitions of offenses under the Act. All right. But I think what is commendable is that the Act addresses somewhat the initial loud silence on gender-based manifestations of the issues that it sought to address. And by the Act, I refer to the Act as amended in 2022. So there was initially a loud silence in the 2011 version on gender-based manifestations of some of the offenses under the Computer Misuse Act, right? So, but the 2022 amendment addressed some of those by introducing a specific provision, and that is section 26D, paragraph 5, right? That new section 26D, paragraph 5, is specifically dedicated to social media. And what does it do? It defines social media as a set of technologies, sites, and practices which are used to share opinions, experiences, and perspectives, of course, including YouTube, WhatsApp, a long list, right? So by doing that, we then see a great improvement in the regulatory response of our, country to digital realities. And this is, I think, very clear in some of the acts that then the Act as amended prohibits, all right, including access to or interception of any program, data, or information of another person without authorization of another person. So that means even now, I think we can actually now address the other issue noted earlier in the context of a domestic situation, to address, domestic violence. But also, it prohibits voice or video recording of another person without their authorization. Right? So the Act as amended prohibits voice or video recording of another person without authorization, prohibits sharing of any information about or that relates to another without their authorization, and sharing of information relating to a child without the consent of such child's parent. So I think your question on children, Susan, I hope Susan is still here. So your question on children violence targeted them, so if a child's information is shared and that is not done by their parent, guardian, or person who has authority over them, and that sharing is not done where there is exceptional legal authorization, and it's not in the best interest of the child, then that's an offense under the Computer Misuse Act. All right, specifically under Section 23A, which is under the Computer Misuse Act Amendment of 2022. That offense actually, attracts a maximum penalty of 750 currency points and or 7 years imprisonment. So it's a significant leap. All right. Other acts prohibited under the Act, Computer Misuse Act, is sharing or sending of hateful information through a computer, unsolicited sharing, or really the offenses that we all know, having read that act as of now, I believe. So the assessment then is that the provisions as they are now sort of reveal, from a regulatory standpoint, that Uganda has started to implement some consensus that is, of course, admitted the recent, you remember the instruments I mentioned, the Joint Declaration of the UN 2018 Special Rapporteur Observations, then 2022, also at the African level, the Declaration on Freedom of Expression and Access to Information in Africa, then also women's protection of women's rights online, and also protection of women from violence online again. So our Computer Misuse Act as amended in 2022 sort of reflects, our kind of proactive, attempt to address some of the recent consensus, at the continental and global level, in regards to ensuring protection of online safety of all groups. All right. For instance, when we look at Principle 42 of the African Declaration and Resolution, then the Recommendation 5 of the Joint Declaration that I mentioned under the UN framework. Now, in terms of access to justice, all of the offenses under the Computer Misuse Act, of course, we know that they fall under the jurisdiction of the Chief Magistrate or the Magistrate Grade 1. And of course, we know their powers, including imposing the full penalty or punishment in respect of any of the offenses there. When we look at Section 31 of the 2011 of the Act, let's say the Act, it's safe to say so. There's also guidance relating to, in the Act, relating to, to the offenses, including the procedures for processing of complaints. All right. When, for example, you look at Section 28, a police officer, can, upon belief that an offense has been or is about to be committed in certain premises, apply for an authorization of a warrant from a magistrate, and then they go and enter into premises where they suspect that offense is being committed or about to be committed, and search that place. For as long as that officer then uses, of course, the other human rights safeguards, reasonable force to do away with arbitrariness. All right. Then there are powers and responsibilities relating to cooperation between investigating officers and custodians of relevant computer systems. Again, you remember the recommendations under the African regional and UN instruments, recent instruments in relation to online gender-based violence. Yeah, so there is cooperation being superimposed in the Computer Misuse Act, Section 28, particularly, but also there is powers of, and responsibilities relating to cooperation with other critical stakeholders, such as the internet service providers and competent authorities that are associated with specified communication communication that is transmitted by means of a computer system. Can be telecommunication, and service providers. All right. So in the context of OGBV, our observation is that then these, regulatory step taken by our legislature then guarantees access to justice by ensuring access within the legal parameters to all pieces of evidence that are necessary to support the case in case of a justice seeker. So where that cooperation, for instance, has been, pursued. However, we note that, excuse me, we do note that sometimes there are difficulties in realizing some of these, in terms of the practice, in realizing some of these regulatory advances, making them work. And as a, an enthusiast of ensuring that the human rights and really standards that we do adopt get to be realized in the real lives of ordinary people in the remotest of the communities, that concerns me, in light of the practical realities that then sometimes may impede that reality, of achieving the protection, So for instance, where the investigating officer is not adequately equipped to map out what leads are necessary, or what links, what connections, what kind of information, which stakeholder is relevant for me to adequately investigate this case, then, and they may end up not, adequately handling the case, and therefore that then means that the provision may not be well maximized. So that then calls into play the other, recommendation from the international and regional frameworks for, again, training of these officers who handle, say, gender-based related offenses, to be equipped to know who are the stakeholders, what are the possible scenarios, and where do you go to when and at what point, how do you safeguard information, how do you then make a case in order to deliver on justice for the justice seeker. But I think it's fair to acknowledge some of the improvements, but also doing that with citing some of the areas that need to be addressed or improved further in respect to the Computer Misuse Act. And one of those is the need to address the lack of specificity as to the elements of malicious information, because you see under section 26C, paragraph 1 of the 2022 amendment, suspicious, it's suspicious that there's no specificity to the elements of malicious information. So where that is that specificity is lacking and it's ambiguous, we risk, gagging some forms of critical communication. For instance, as you have seen recently in the exhibitions, the popular exhibitions of different entities and persons in government and I think in the NGO sector partly. Now, if the Computer Misuse Act is ambiguous on the definition of malicious information, then critical communication, such as naming and shaming of authoritative figures, may be gagged, and criminalized or even prosecuted as malicious information being shared by those who communicate using the computers. In order then to sort of guard against the persons that information relates to, guard them from being brought to account, again affecting several other aspects of society and rights in particular. For instance, service delivery, where, for instance, the allegations of corruption, but then these are not pursued because those who are communicating using the computers are then charged with sharing of malicious information under the Computer Misuse Act, that provision 26C, 26C1. But of course, also you remember that in January 2023, last year, in that important case of Andrew Karamagi and Robert Shaka versus the Attorney General, the Constitutional Court nullified, Section 25 of the Computer Misuse Act, which had provided for the offense of offensive communication and for being vague, overly broad, and ambiguous. In the view of the court, according to the judgment read by Justice, as he then was, now late, Kenneth Kakuru, the offense was, what constituted that offense was unpredictable. And the fear was that then gives the law enforcement the discretion to pick and choose what qualifies as offense, right? And that unfettered discretion would ultimately then be perhaps used to punish unpopular or critical protected expression, as I've stated, for instance, in respect of the exhibitions that have been happening and continue to happen online, specifically on X, formerly Twitter. Now, of course, we know that the Act also does not explicitly require the investigating officers handling a case of online violence to adopt proactive and gender-sensitive approaches. Now, that is us trying to be more gender biased. We want to have the gender lens is explicitly mandated in the handling of these cases. But the Computer Misuse Act, as it is, does not, specifically require the investigating officer handling a case of online violence to, adopt proactive and gender-sensitive approaches, such as ensuring that intermediaries, those who have who facilitate communication online, for instance, there's no requirement for them to expedite the removal of harmful content, right? But when you look at Principle 39.5 of the African Commission Declaration on Freedom of Expression and Expression, and that recommendation for AI hinted at of the UN Joint Declaration, some of these specific, gender-sensitive approaches are actually emphasized, to be adopted by states. Okay, so now without that specific specificity of requirement and expectation from investigating officers, investigation of such offenses becomes a little complicated, especially where it involves, impact on gender minorities, right? So on the basis of that, I think there's need to invest heavily in wider recruitment and continuous specialized training of police officers in the investigation of OGBV, so that then, even as they are not specifically explicitly required by the law, they can, as a matter of default based of their training, but also ultimately in hopefully passion as a result of the training, then apply the gender lenses to their work. Ultimately, the beneficiary are the victims of online gender-based violence, or survivors, as should be referred to. So you realize that in the course of the discussion, I handle both the status quo, some of the challenges, but also proposals for reform, right? And these are things that we have in mind, and I think I would strongly recommend, if you don't have access to the report yet, to secure access to that report done by FIDA last year. It may not be 100% comprehensive, but it offers a starting point on the reflection on some of the areas that we need to emphasize as lawyers, but also as actors in the field, to enhance protection of our communities from online gender-based violence, both in terms of applied the law, but also generally in terms of then how we get to protect and safeguard ourselves as also potential victims or targets of these acts of violation. Now, moving on from the Computer Misuse Act, there's the Data Protection and Privacy Act of 2019. Of course, that relates to regulation of data. That is in terms of its collection, processing, and control. Data being personal data. Okay. And under that law, there are important, innovations, including, it providing for the principles which must be followed by any person who collects, processes, controls, or uses personal data. So the principles that are provided for include, doing anything within the act. I mean, processing, collection, control, and use of personal data lawfully and fairly, right? Then being accountable to the data subject, the person whose data you're handling. The responsibility to only collect, process, use, or hold adequate, relevant, and not excessive or unnecessary personal data. In other words, if you come to collect information on me on something, let's say, relating to health, then that may not have anything to do with my, say, finances, right? So you should keep in your lane lawfully and fairly, but also to the extent that that data you're collecting is relevant and not excessive. Then also, of course, there's the requirement for data handlers to observe security safeguards in respect of the data that they deal with. Of course, importantly, the issue of consent of data subjects, they must consent to their data being collected and processed, but also data that relates to their children and under their care or their own children, and the fact that the sharing and usage of that data has to be only to the extent that is necessary. Non-consensual collection of special categories of personal data, such as that data relating to sexual life. Now, this is a little problematic, including, in the context of Uganda, sexual orientation. Such data is not supposed to be collected without consent. Financial information cannot be collected without consent. All right? Political opinion, religious or philosophical beliefs, but also data relating to an individual's health status or medical records. That one can only be shared with the consent of the data subject, right? So that's considered to be among the special categories of data protected under Section 9 of the Act. Of course, a number of other duties under that law, including, ensuring to employ sufficient security safeguards to prevent loss, damage, or unauthorized destruction and unlawful access to all unauthorized processing of the personal data, and where any breaches have occurred, you have to notify as a data handler the Data Protection Authority for them to be able to guide you. So that is within the provisions under Part 4 of the Data Protection and Privacy Act. Again, in terms of access to justice, the Act does us good by providing for a complaints mechanism, appeal against decisions of the authority, blah, 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 blah. But of course, that Act had to wait up to the 2021 when the relevant regulations were issued. Yeah, and under those regulations, some spectacular features include, a detailed provision for a resolution mechanism, dispute resolution mechanism, relating to the offences under the Act, including imposing a 21-day limit on the handling and adjudication of complaints, but also then providing for timelines and procedures for appealing. So that appeal to the minister is supposed to be handled within 30 days of it being received. Whether that happens in practice or not, not on the ground you can advise. But in handling the matter that has been, forwarded to the minister on appeal, and again, as part of making it easy for the complaints to be dealt with timeously, and in light of the, wider mandate of some of these ministers, the minister has the discretion to constitute a committee, of officials in the ministry or any other, ministerial department of government or agency to assist them according to Regulation 46, So our expectation from that provision is that then the minister would have to consider bringing on board gender specialists, some of you, for instance, now or in the future, and other experts that are necessary, so that when the minister is handling an appeal which relates to the data breaches, data breaches that relate to online gender-based violence, victims, then there is that sensitivity and appropriateness of approach, and therefore to serve justice. Okay. Yes. So, but still, even as largely the law is in sync with the standard provided by guiding tools such as principles in the declarations we talked about, there's need for strengthening in some aspects, for instance, including contraventions of personal data that manifest with an OGBV, with an element of gender targeting or gender-based violence. So we know that, yes, it's illegal to access data without consent. It is illegal to share that data without consent, blah, blah, blah. Those other provisions we've seen, the prohibited acts under under the act. But we are not yet seeing an approach where then the law makes it, for instance, an aggravating factor where those offenses are committed specifically for, to harm a person because of based off of their gender, what is called a gender motive, a gendered motive, a gendered crime. So OGBV could best be addressed if we have some of those offenses in these instruments that are specifically relating to online data management, as being addressed with an aggravating component, that, hey, if you commit it with a component of aggravating factor, and therefore the sentence is graver. Moving on to the Anti-Pornography Act. Of course, I think that's one of the most notorious one. So part of our approach or attempt to regulate information and communication technologies, and with a view to ending, to protecting and things like public morality, was the adoption of the Anti-Pornography Act, a law that was ambiguously, drafted. It is generally considered to be a victimizing legislation, the Pornography Act, The long title says that the Act seeks to define and create the offense of pornography, provide for the prohibition of pornography, establish the Pornography Control Committee, and prescribe its functions, and for other related matters. Section 13, production, trafficking in, publication, broadcasting, procurement, importation, etc., or sale or abetting any form of pornography is prohibited. And when you contravene that, there is a penalty, maximum fine of 500 currency points or a 10-year prison term. Specifically for children, again, there is pen for pornography, which is specifically, defined to include depicting of images of children as an offense, which attracts, again, a sentence of 750 currency points and or 15 years in jail, right? So there's a definition in section 2, but in 2014, that act was challenged by the Center for Domestic Violence Prevention and others in Constitutional Petition number 13 of 2014. So the Constitutional Court of Uganda declared the heart of this unconstitutional, even as it upheld some of the elements in that heart. That heart is the definition of pornography under Section 2. For purposes of those who may not have seen the act or have it close by, that section provides defines pornography any presented through publication, exhibition, cinematography, indecent show, of a person engaged in or simulated these sexual activities or any representation of the sexual parts of a person for primarily the sexual excitement. But the court upheld some of the definitions, some of the elements in that definition, including, the fact that, stimulating, sorry. Excuse me. Yeah, so the court upheld some of the, aspects of the definition, but which it noted weren't vague, ambiguous, and uncertain had been urged by the applicants. But in the research report, you'll be seeing of course, we know that some of the duties were very sort of include, failure to provide what amounts to indecent show, and the threshold over which an action can be measured to determine whether it falls within the ambit of indecent show, right? And of course, the concern was that the failure for this to be a clear risked inconsistent application of the aware for to go ahead and arrest and charge victims of revenge pornography. Revenge pornography is a thing, right? Somebody talked about, for instance, what happens where the victim of online gender-based violence actually mated or did something, and then the person is revenge. Say if that revenge is by pornography, then there is challenge, because then the ideal person to deal with would be the person who actually shares the acts, or who commits acts that amount to online gender-based violence. For instance, sharing of intimate images. So it would be revenge pornography, irrespective of what motivated the person who shared the pornographic images to that. So of course, we have had a few examples. Judith had in 2019, you remember, when nudes were leaked, she was arrested. Of course, a lot of mocking and shaming of her, in the media. Same with Desire Ruzinda. Of course, you remember Martha Kay. Now, recently, we've seen, we've had, a few other developments. Shiraga Shumba. We have had, but of course, those have not yet interacted with the legal persecution, as it were. So, but also the Act has a few other contentious features. For instance, it provides for instance of a body known as the Anti-Pornography Committee, with the mandate to ensure early detection and prohibition of pornography, apprehension and prosecution of perpetrators of pornography, a number of other mandates under Section 7. Under Section 11, that committee has the power of enforcement and policing of pornography. including inspection, search, and seizure, subject to judicial action, all right? But we wait to see then how subsequently the act will be implemented, all right? So that T is yet to be functional because which is the heart of the act has been contested successfully in the court, then the anti-pornography committee cannot really function because its powers are premised on that decision, all right? On that definition is contested. Of course, wide is for internet service providers, to, for instance, recommendations made to them by the Anti-Pornography Committee to control pornography, not to permit pornography to be uploaded or downloaded through their sites, etc. under Section 17. But then, because the Act is a central pillar, which the definition is revisited to be constitutional, unless it has in the recent past. I've not checked in the last few months. Then implementation of some of these rather progressive provisions also becomes a little tricky. So protection becomes a bit of akin to with client. But yes, we welcome the explicit mention of technology in the definition of pornography because that reflects, the recognized standards that we discussed earlier, and especially the protection of children from digital harm, and also recognizing their evolving capacities. But we also note that the provision on the offense of, child pornography in the Anti-Pornography Act don't explicitly protect children from exposure to the recipients, so it also falls short of addressing phenomena and public figures that gendered pornographic crime, that is targeting women or other gender categories really as aggravating factors, all right? So that is, I think, pretty much about the Act. Maybe we need to emphasize also the need for that law to stem the culture of secondary victimization of victims by expressly prohibiting the insensitivity with which we have seen some cases, being handled as cases of online gender-based violence, I mean, that Judith had, so desire the Honorable Minister, Reverend Father Lokodo, we're going to arrest her, then the prosecution, and so that is not gender sensitive, and we need to ensure that our clients are protected. So generally, that is it for the laws, and I think this is the point where before we go into the institutional framework, I get to hear some feedback from you. What have been some of your experiences with this framework? Especially those of us who indicated that we have dealt with some of these cases in the feeding of our pre-evaluation, pre-training survey. Okay, so I take it that there are no responses at the moment. Opportunity for responses going once. Going twice. Okay. Well, possibly also maybe because some of these are still new, maybe we just look forward to the opportunities that they present us to, and I implore us to then venture into maximizing the strategies that can, help us better achieve justice for survivors of online gender-based violence, so that then justice is delivered substantively to them. So that is it really for the institutional frameworks. Of course, as lawyers, I may not, have to so much bother you with so much about, the institutions that are responsible for these use. You see them under the law, but then what we make in conclusion in respect to the legal framework at the domestic level in Uganda. Very important strides made. We see that we are making progress in aligning as a country our existing regulatory tools to to respond to OGBV, and that is commendable. But we need to, I think, again work towards ensuring that the application of these is consistent, and that review processes. Of course, you know that some of the problems around the Computer Misuse Act amendment of 2022 was it being perceived as a political tool, given one, the context within which it was brought, but also generally the fact that, again, that political motive, very important provisions that then we have seen actually can go to a greater degree in ensuring in preventing would be targets of on gender-based violence, from suffering it actually. All right. So we cannot leave, therefore, reform processes to political events. We can't be triggered to do reforms under the heat of political moments. We should ensure to have comprehensive reforms that then cater to all issues, and to ensure that then there's full and meaningful participation and support of all possible stakeholders. So I think now, with that said, Lynette, ideally, on that agenda item on the group exercise, my proposal is for. Can you hear me? Yes. So my proposal for the group exercise would be then for us, given that I have not had responses on the, had the benefit of having responses on the framework now, is for the participants to then in smaller groups of about four, in about four smaller groups, then reflect on some of the cases cases they have handled or have heard of in practice that they feel either were handled effectively or should have been handled better. So then to discuss those cases, one or two cases that they consider to be the most prominent, and then share in about 30 minutes, share what their reflection is based off of what they now know on how and why those cases were held appropriately in the gender sense, or what they think could have been done better in some of those cases. We have a number of them. The case involving Sylvia Rabogo with Brian Isiko. We have the case of Judith Hard, the prostitution procedures, and but also a number that they could have come across in their practice. Over to you.
So what we're going to do, Hi, Green Group, hello. Can you hear me? Hello? I'm not so sure that I can be heard in this group. Oh, okay. Okay, so this is still the main group. So I think Mabel is no longer in the meeting. I think she needed to step out to go to court. Or okay, Mabel is here. And so Mabel, if you can take the lead for the discussion in this room, which is the blue room, that would be very good. And just to repeat the question, we are to discuss the cases that we know as lawyers, the cases that we had come across, that we can, that we know very well, and assess what has Uganda done in terms of litigating online gender-based violence. So as we do that discussion, I'm requesting that a few of us step out into the green room. Abby, Deborah, Victoria, Claudia, if you can join me and we step out to the green room so that we have an equal amount of participants in both rooms, that would be great. So please just follow the link, the 4 people I've mentioned, and then we join the meeting in the green room.
Lynette, could you kindly help me share the links to the rooms? I jumped out. I had a network issue.
And it has just been reshared.
Let me. Hello, good afternoon. I hope everyone here is ready to participate in answering the question that has been shared. So I call upon each and every one of us to share as much information as we possibly can in answering the question, which states, what has Uganda done in terms of litigating online gender-based violence? So feel free to unmute and give us what suggestions you have or what you believe Uganda has done in addressing online gender-based violence. Colleagues, is there anyone who would love to go first? Victoria, Rehema, Flavia. Colleagues, could we please provide some information to this?
Mabel, I beg your pardon on that question.
The question is, what has Uganda done in terms of litigating online gender-based violence?
Litigating or mitigating? Litigating or mitigating? Litigating as in court.
Litigating, at least I
Okay.
believe.
I wanted to just be sure before I answer. So I remember not so long ago we had that case where the minister, I don't think Uganda has really done much when it comes to litigating online gender-based violence. And this partly could be because the judicial officers, the members of police don't understand what online gender-based violence is. And I will take you back to that case, the minister's case, where but guess what? She was being stalked by this boy. He was referred to famously as the internet lover boy, who used to stalk the minister, send her messages. It was borderline harassment. And the case that finally went to court.
Yes.
Sorry about that. The case finally went to court, and the guy was sentenced to, I think, was it a year or two. Unfortunately, when they appealed, this case was sent back to a chief magistrate's court for retrial on a mere technicality. I think they did not treat him when he pleaded guilty. They don't treat for him. You know that procedure when you plead guilty, then they have for you your offense. What I think the magistrate skipped that, so it was sent back to court for retrial. It was a mere technicality, but it was loud because when it went back for retrial, nothing has ever gone. Actually, I think the minister is no longer interested in pursuing the case, so eventually it was dropped. Yeah, she's no longer, but it was dropped by the DPP. So, and that was like the only case we have had so far, like go to court in regarding to online gender-based violence that I really know of, because I've really tried to read about these cases. So we don't have any jurisprudence in court for us to rely on. But then again, of course, you do not blame the judicial officers because there is no direct law that can give them this that they can fall back on. But also, when you follow this court, remember the magistrate that handled this case, the backlash that she received was when she sentenced this guy. When imagine he even pleaded guilty, but the backlash that she received from the community, those who on Twitter by then who are following, they abused her. This woman, she's stepping in people's love. We have a right to love people. Like she got a lot of backlash. So I feel like this also kind of deterred some other judicial officers for taking on this case. So I feel like it contributed to people not wanting to pursue these cases further because of that kind of stigma that is around online gender-based violence. Another example I will give, you remember that incident of Judith had that police officer, and her name was, whose nudes leaked online. Judith had the nudes leaked online. When this young girl for UCU as well, who sent nudes to their boyfriend, and when they broke up, he released the nudes. Like we have seen that the the law that we have in place, it's not a lot, but what we have in place is now as a sword. You know, that terminology of the law is a shield and a sword, but it's now being used as a sword against the victims, in that it's now the victims that are receiving the backlash. In those three examples I've given, Judith had that girl, that young girl from UC and the police officer. They were the victims, their nudes were released online, but who was prosecuted? It's them, the victims. Like the ones that released the nudes went away scot-free, like nothing was done to them. But these women have stayed behind dealing with the consequences of their nudes being online and being actually prosecuted for that. Not so many people really get to have a comeback on this, but still, I don't know why the case ended, because I tried to follow, but the case did not proceed further. But just that statement that was made by the minister and the police going further to prosecute him for releasing pornography. You can imagine, but I'm not the one who released this pornography. Like, I took these pictures for personal use. So when you look at the definition of pornography that the law sets out, you're recording, like you're making it with an intent of publicizing it, but this was not the intent. So like the mens rea was not present, but that the ones who end up being charged with the offense for releasing pornography. So I really don't think, in my opinion, that we have a lot of that. Uganda has done a lot to litigate online gender-based violence. So we are really still at a standstill. Even if you take cases to police, nothing is done about them, because I'll go back to limited knowledge. Thank you. Maybe somebody else can add from that. Thank you.
Thank you so much, Abby, for that wonderful presentation. It was really, really informative. Anyone who would love to add to Abby's voice or share something different from what Abby has shared, please unmute your mic and share.
Mabel, I would like to add on to what Abby has said. Not to really differ from that, I really associate myself with that, in a line that Uganda has really not done that much, but also to appreciate at some level that the enactment of the different laws has been a contribution towards curbing or maybe fighting GBV, online GBV. But in the line of litigation, there's a lot still lacking. You can look at the fact that the enactment of laws like the Penal Code and also the Computer Misuse Act, the amendment was for 2022, something that is greatly in line with the online computer, tech, phones and everything in that line. And the offenses under that are really in line, that they could be something we can rely on and say Uganda has actually taken a step towards the fight of GBV, online GBV, because we look at situations where people are like their names are tarnished on social media, they go live, like someone decides to put up nudes up there and nothing was done about it in those years and the previous years. But if you look at the Computer Misuse Act, it has different provisions that can get these people brought to book. And I feel for some reason, if you look at the previous years and from 22 to now, the release of nudes, the online GBV has really reduced, and that is my perspective. It's how I've seen it, and I've come to appreciate that this act, much as it was criticized for a long time, it had a lot to do with curbing this online GBV. And also now the response, like for example, people keep posting videos of people being battered online, like they post on a reel on Facebook, and within a short period of time you realize this person has been arrested. And yes, you see Enanga giving a statement on that, and I feel this is something that we can commend Uganda for. But also the laws are still lacking in that line, like Abby has said, like the other lover boy who really went scot-free. It wasn't that easy for the woman to really accept that something that big can happen and a person goes scot-free, because there are laws lacking, because at that time really the laws were really lacking for that period. I think this is the brief I can add on. As people add on, maybe I'll come in again if there's anything to add. Thank you.
Thank you, Rehema. And Abby, once again, Thank you, Rehema, for supplementing onto Abby's presentation or submission. Is there anyone else who would love to share? Probably you would love to share the barriers that we have come across in resolving these cases.
Mabel, can you
Yes,
hear?
Victoria.
Yes. So maybe the other case of Martha K, I feel like it had it had some progress, but from what I observed in that case is that there are many ways to actually make sure you can litigate when it comes to cases of online gender-based violence, and that is the fact that there are many other offenses involved. So for me, I believe in Uganda it's easier to litigate on such cases when you can add other offenses on the charge sheet. Because from what I recall is that she was actually drugged and there was some bit of extortion, and I think the guy also had some charges of aggravated robbery, and that's why the case was like it tried to really proceed, and he had applied for bail, though I don't think it was granted, but still that was the end of the case. But I think he was never granted bail. But because he already had like other charges that they considered capital in nature, I don't think the sole basis for denying him bail was because of leaking her nude photos. So for me, in a way, and like recently I've interacted with someone who confided in me that she's a potential victim to this online gender-based violence, as someone wants to leak her nudes and sell like her nudes and videos to newspaper companies to publish, and those websites that develop and publish pornographic material. So it is very hard to actually go against this person on the basis of one offense that this person wants to like leak my nude photos, but there should be like some other charges to like pursue this person because it's actually quite complicated. And I think extortion would be great because most of the times the person actually wants to be paid out. So I think that's the line which most people would take to ensure that this person can be arrested and actually charged in court. That is my observation.
Okay, thank you, Victoria. It is quite sad to note that online GBV cannot stand the test of time in our legal arena, especially when trying to prosecute it in courts of law. That's quite absurd. Is there someone else who would love to share something? It could be in relation to the barriers we are facing, like I said, when we come across these cases and when we are trying to resolve these cases. Just like Victoria has said, it's hard for these online GBV cases to stand alone. In most cases, perpetrators have to have multiple charges against them before they can stand in court, before they can be prosecuted in courts of law, which is quite unfortunate. So are there some other barriers that we have come across or that we know of or that we have been talking about in these spaces that are actually affecting prosecution of these cases?
Hi, Mabel again, Sabi again. Just to add on what Victoria said. So now, imagine what happens if somebody, like you've just really been violated online, like there's no other, okay, maybe it's just offensive communication or something, but like there are no other offenses that we can ride on to have this case prosecuted. Then what then happens to this victim? You get it? Like the law, we need to now move on to be able to acknowledge that this is now happening and something needs to be done about it. All the laws that we are relying on were enacted in about 2010, 2011, apart from the Computer Misuse Act, which was recently amended. But most of these laws are 2010 laws. And you and I, all of us here, we can testify that 2010, that's when internet was just becoming a big deal in Uganda. Like, that's when we were all having creating just Facebook accounts and all. So people didn't even, and by then there was no violence. Like, it was really still a safe space. People were still innocent on the internet. But the use of internet has really migrated. Like, it has grown where we are seeing all these vices cropping up. However, the laws are not moving at the pace at which the internet is moving. The laws are still stagnant, and little is being done to mitigate them. So if I'm being invited and receiving news online, like can government do something to protect the victim? Like, I don't have to wait for unoffensive communication to happen, and I can ride on that to take my case to court, which may not even happen. You know the challenges that we face in access to justice. You go now, somebody, for example, somebody you're in Masaka, I'm giving an example, where the nearest police post you're going to report doesn't even have a computer. They are not well funded, and they're going to go and investigate. So how are we going to collect this evidence? Even if I come and hand you my phone, how it is rigorous. People who go to court actively, how it's hard, like how evidence must be kept, the chain of evidence, like from collecting it to storage and preservation, taking it to court, you need an expert. Who is going to fund these people? Our policemen are not actively funded. They're not well funded to be able to do this work. They don't even have a laptop, no smartphones. I've seen instances where policemen are holding button phones. So how are you going to expect them, like even if they feel your pain, but how are you going to expect them to do all this investigation that is required to collect that data? It is very rigorous data. You have to track for the IP address, get this anonymous user online, because people even use pseudonyms online. But if you have the IP address, which is more work that the police, somebody in Masaka is not willing to do. Maybe if you come to Kampala, the big police stations that have the resources, they could be willing to do. However, you need to fund them. But the communities that we are working in, or the people in Uganda, many can't afford to fund police. Just mere tracking up your phone when it's lost, if the police can do that, it will cost you about 500 and you will never even get the phone back. So it becomes a big challenge that even if we have the laws, the evidence collection processes, like from reporting and collecting evidence, are a bit rigorous and rigid. Plus, even the laws are not being amended at the pace at which the internet is moving. So it becomes another challenge for the victims.
Wow. Thank you so much, Abby. That was very, very comprehensive. Is there someone else that would love to share something?
Mabel?
Yes, Victoria?
There is another challenge that the person I was talking about also raised to me. She was saying that sometimes people do not report cases or follow up those cases at police because of the shame that comes with being associated with your nudes being leaked. Because at the end of the day, these policemen are going to access the material, your friends are going to access it, your parents. So most of them prefer to hide away and cope with the effects, the mental health challenges that come up with having your nudes released. Specifically for this person, she was talking about being suicidal, the shame that is causing her, and she has actually currently even run out of the country, and so she cannot even make a statement because she's running away from these problems. So I think also the kind of we do some victim blaming even between ourselves. You'll find that in a group of people maybe you studied with or someone brings up an issue and they say, okay, this person's nudes have been leaked. Not everyone is going to agree that we shouldn't be spreading the information. Instead, people will ask, let me maybe look at this, let me share. So you find there are many people from the person maybe who bought from the original seller, people are distributing, accessing them on free online sites, posting them on Twitter. So there is also that coverage that's increased when people know that someone's nudes have been leaked. So those are some of the other challenges that I've noticed.
Thank you so much, Victoria. It is sad to note that we do not have safe spaces in which we can confide in people, and that in most cases, like Victoria says, leads to self-victimization, and in the end we will be registering a number of suicides happening within our communities. I would love to hear from other colleagues on the call. If you have something to share, something to say, please unmute your mic and share. Anyone else on the call? in need. I would love to hear from you, Leah, Brenda, Claudia. Colleagues, would anyone else love to share their thoughts? Would anyone love to share their thoughts on the barriers that we come across when resolving OGBV, or how the legal framework is really serving survivors? Yes, 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 Lynette. We are ready to report back from our discussions that we're having.
It's okay. Good afternoon, everyone. Well, in our discussion, we looked at mainly the cases, the different clinics we handled in relation to online GBV. And our discussion mainly pointed at the main cases that came out were the divorce, whereby the ex-partners or boyfriends keep on bullying or sending threats to the victims or the other partner. So you find that it becomes hard or it comes tormenting to the other partner because of the different torment that come with WhatsApps and other social media forms. So with what we discussed, that when these cases are reported at police, mainly the victims would not follow up because at the end of it all they say like maybe the whole world has seen it, or what will happen after, it will not repay back, or it will not put me back in a situation I was in before. So you find that the victims will leave it at that. Even when you try so much to follow up with them, they feel like at the end of it all, it will not be so useful. Uh, and then the other part that we looked at what has Uganda done to end online GBV. Okay, we didn't have so much discussion on this, but with what we have discussed, we see that there are very many loopholes in the law, that very many young girls or students at university that are experiencing this kind of cyberbullying or online GBV will normally not come up, or even if they come up, they end up covering it up because they feel like they will be so ashamed out there. Like they lack confidence. So I think our laws are not like we have not yet sensitized enough. We have not yet. Okay, we are lacking a bit because even if you have a client on one and you tell them the importance of the law and how they are tormented or how their kids will be punished and all that, they will end up asking themselves what will I gain or what will I achieve by this. So to us in our group, we have said that and we conclude that the laws in place have a little bit of loophole, and as a country or as a nation, and then the different institutions in place have not done enough to protect or to guide the victims of GBV, online GBV. Thank you.
Thank you so much, Lynette. Um, the Blue Group was tasked to discuss cases that we have interfaced with or read about, the barriers that we have come across in resolving these, and how the legal framework is really serving survivors. For starters, I think the government has done the legal framework that I would prefer to call the government in this case has done so little to actually serve survivors of online GBV, despite the fact that there are so many laws in place that point towards criminalization of OGBV. Little has been done to actually curb the vice. And some of the barriers that we face are lack of specific legislation. Whereas we have the Computer Misuse Act and the Penal Code Act and so many laws in place, it's important to note that the legal frameworks may not specifically address all forms of online GBV. This leaves survivors without adequate legal recourse, and as such, they find it hard to actually seek justice from courts of law. It's also important to know that existing laws may not encompass the complexities of online harassment, stalking or non-consensual distribution of intimate images. So that's the first barrier we face. The second barrier is underreporting and stigmatization of OGBV survivors. Under this, OGBV survivors may hesitate to report incidents due to fear of retaliation, with concerns about privacy and societal stigma rising. This underreporting most often results into lack of data on the prevalence of OGBV, and in most cases leads to inadequate responses from the authority. Still underreporting and stigmatization, due to the lack of privacy or infringement of privacy, survivors of GBV find it hard because we do not have safe spaces within the reporting arena. We do not have safe spaces where survivors of OGBV can actually confide in someone and have trust that their information is not going to be shared with probably colleagues or friends or family, even with or without their knowledge. So because we do not have these safe spaces, we are facing a lot of underreporting. And in cases where we report or where the survivors of OGBV report, there's a lot of stigmatization that is going to come from within the society. That also results into survivors having suicidal thoughts, and the country, or the police rather, registering a number of cases on suicide. Another point is digital literacy and access to justice. Many survivors lack the digital literacy skills necessary to navigate online platforms and report incidences of OGBV. Such barriers, additionally, barriers such as costs, language, and geographical location may limit survivors' access to legal assistance and support services. Take, for example, in case a lady, let's say, hypothetically living in Adjumani, is a survivor of OGBV, but to her, she does not actually have knowledge on digital literacy. She's illiterate on the digital network or platforms that exist. Even when her nudes are, for example, in this case, are leaked, it's going to be so hard for her to report this case. First of all, she may not even have access to this picture. She may just be hearing rumor from friends, and this alone causes her a lot of mental trauma. But in instances where this lady, let's say, was digitally literate, then she would be able to file a complaint and follow up on the case, probably if stigmatization is not in the picture, or even if it's in the picture where she's willing to actually follow up on this matter. The other one would be inadequate enforcement and resources. We all know the police is underfunded, and this greatly affects the chain of evidence collection, protection, and maybe production. You get to realize that in these digital cases where we have components of IP addresses and so much more, it's very costly. It's very costly hiring an IT expert or an IT technocrat to do this work for you. In most cases, even the police people that can do this will need funding from the survivors. In most cases, of which the survivors will not be able to provide the funding. So the fact that the police is underfunded really constrains delivery of justice for survivors of OGBV. And then normalization of online abuse. If you realize when you get to Twitter, especially Twitter and TikTok, there is a lot of online abuse going on, and it's very normal within the community. In most cases, you find someone is going to take a screenshot of a tweet or save a TikTok video and send to a friend who's going to send to a friend who's going to send to a family. And it's very normal because people are going to laugh it off. And this just undermines the survivor's confidence to seek justice and discourages meaningful action against perpetrators. So it's against this background that in our discussion, we felt that the government is really doing little to serve survivors of OGBV. And as such, these are barriers that are hindering access to justice to survivors of OGBV. Thank you.
Thank you, Lynette, and thank you to you all. I feel fired up. I hope we can have this tomorrow and the other day, a similar engagement on the issue. Not because there are nice things to hear in the ears, but because it shows how much more work there is to be done. That's one. Number two, of course, what is coming through from your responses to me, I think, and to FIDA confirms the findings that we made in our study last year. Issues around enforcement, ambivalence of actors, but also the general backlash from yes, the law enforcement officers, but also really then the would-be support systems on account of normalization of some of these things. So thank you so much for sharing those perspectives. And I think they speak so much to what we see, of course, the trends that are coming through. Various categories are affected, some in almost similar ways, others a little differently, but they're all issues that we have to address. We have noted women are affected, non-consensual distribution of their images, sometimes as a result of revenge, body shaming. Those are some of the trends that also came through from our report. Inappropriate comments, carrying sexual innuendos, some of course disguised as jokes. There is an experience we noted of a lady who, posted online in response to a person who had again asked a question that she thought was innocent and needed an answer, and what turned out, what returned were innuendos of a sexual nature, which are unwelcome. So yes, I think I will not really take so much time to reiterate the experiences, but to say that really then they need to work around ways of protecting, survivors. Then is more enforced through the perspective that you have all shared in the course of the group sessions, which reflects actually the work that you do. So in the next about 20 to 25 minutes, I hope I can do less than that. I see we've already spent close to 5 hours as of 30 minutes from now. I want to run us through then what we can do to ensure enhanced protection. Some of they are really general ideas, but can be a working framework to guide our approach to gender-based violence prevention, and especially gender-based violence online, in light of the increasing need, especially for women participation, for instance, in politics. We had a respondent who, was involved in political activism and actually deeply involved in some of the exhibitions that I was hinting at in the last few hours. So she would receive sexist comments, but also attempts by none other than the law enforcement, entities, law authorities to, get to know whom, she was having affairs with, whom had she slept with a view to now finding sex tapes to leak them, so that then they discredit her other broader work of public participation. Of course, the goal is to silence her. And you can see that then actually, yes, perpetrators are within our domestic context, they are within community generally, even on the blogs, as you've seen, and on social media platforms. But also, quite unfortunately, it is also, OGB is also being instrumentalized by people who are supposed to be custodians of the tools of protection, but also the mechanisms that are supposed to respond when violation happens. And of course, perhaps that is beyond our capacity to address, but I think there's need for a soul searching on all fronts, the whole of society approach, as we recommend to users of online platforms to be more responsible, as we recommend to you, to myself, and to others, our sisters and mothers and children, to be more vigilant in the way they engage online, who they talk to, and which information they share, to be sure to protect themselves through those protocols. We also, I think, have to involve as well, really, and I think more honestly, those that are responsible for grander schemes of a violation of these rights, and who may be ordinarily beyond the reach of justice institutions, security operatives and whatnot, to act in a way that then upholds rather than abuse human rights that actually their establishing institutions have committed to. And of course, the impact of OGBV perhaps as a motivation for us to work harder and more fervently to ensuring that it's addressed. Mental health issues, depression, some even choosing to withdraw from online activity after, say, they have been exposed or been threatened, body shame, so they withdraw. And again, ultimately, it is a systemic injustices that then get to to kind of dominate the reasons for that withdrawal. Perhaps men think women should not make these kinds of comments, or because when a woman participates publicly and she's shamed or her nudes leaked, then she will stop. A man, maybe it may not matter. We have a few who are taking pride in what happens online. Maybe for them it's not that much of an issue. Of course, it affects career, and in case of children, of course, we know the debilitating effect that has on their growth, both in terms of confidence as individuals, but also really then their academic progress, especially where there may be instances where, say, their fellow learners are mocking them over their experiences online, which may have been online gender-based violence for them. Facilitating factors, still, you have mentioned them, patriarchy, right? And for the longest time, we had poor legal regulation, which bred the impunity that you see then, with which some of these things continue to happen over and over, sometimes with little success. And also the legal regulation, I think part of it is also complemented by, again, an apparently weak or not necessarily very committed mechanism of enforcement of rights, or and a mechanism that does not necessarily respond to the gender dynamics that are associated with the cases that are brought before them. Remember how the Honorable Sylvia Rabogo had to withdraw from the case after that, she had to weep in a court when being interrogated about, the messages that a one Isiko was sending her. And then later, when her case was, challenged on account of a technicality, which was, the justice who was involved, the magistrate who had been involved, I think she was touched as a woman quite naturally that, the nature and conduct of these accused suggests that, he is actually guilty, so they enter a plea of guilty, which the accused are not pleaded. And then on that basis, the trial was, quashed, and, later on it came back for, again, to the court. But because of the frustration around the way in which the case had been handled and the publicity around it and the reckless reporting by the media, ultimately Honorable Sylvia withdrew from the case. And that does not, of course, favor anyone. That does not benefit anybody. And it only goes to now sort of embolden perpetrators, because they know sometimes some of their targets may not successfully pursue justice. It is our work as lawyers to then push to see that the weaknesses within institutions, but also the manner in which the media handles these cases and the bureaucracies around justice service value chain are addressed, so that then we ensure that our clients and those that we know and care about access justice. Okay, so that is generally, I think, much more in line with what has been shared. But I wanted to speak a little more briefly about the issue of protection of children from online gender-based violence. And it, I think, for me, seems that we are likely to run a risk of assuming that children are only victims of online gender-based violence. It may be very easy to assume that they are only victims. But actually, children also perpetrate OGBV against fellow children, say boys with misogynistic tendencies, again, engaging online, harassing, and all other manner of abuses against girls, simply because they think she's simply a girl, she's a woman. They feel that entitlement, to their bodies, access to bodies, demand for pictures. Show me or send me your nudes, send me your a photograph of your, a photo of your upper body, blah blah blah. And when she denies, then that becomes a basis for insults. You don't have belief in yourself. You're not even beautiful. Okay, and so even children actually do perpetrate these acts, and some may go to as far as those that are defined as very criminal offenses, including grave offenses under the laws that we saw earlier. So we have, I think, as lawyers then to look to ways of ensuring that our approaches, of course, ensure protection needs of children as primary victims of OGBV, but also to look at them as potential perpetrators and then how to address them as such, okay? And within the confines of our criminal law, children's accountability for juvenile behavior is required to be pursued under, the means prescribed, by the Children's Act, child-friendly juvenile justice processes, the Children's Act, of course, we know that yes, it approaches justice from the perspective of both children as offenders, but also as potential victims, but also really then as persons who need to be guided to become responsible citizens. Okay, now having said that, the general outlook on our legal regulatory framework and policies suggests some level of progress, okay? But as you can tell, and I've heard through the groups, that much of these frameworks have not yet been tested successfully, right? And that void is because either the frameworks are recent or because those that would have been enforced, were challenged successfully in court, aspects of them, say definitions, for instance, of pornography, and they are pending review for them then to be utilized, right? And I think that's one area that we need to pursue and follow through with, to see that the reforms are made to ensure that then the objectives, the legal, justiciable and reasonable necessary objectives of those laws are met through real life experiences of our clients by enforcing them in court, but also having those perpetrators put to account. So what can we do from now on with the knowledge that we have? It may not be the entire knowledge we need, but as a starting point, at least we have pointers to some of those, tools. We can base on those to guide communities through pro bono services and also defend the defenseless. Access to justice remains a crucial need, but also one that is far from reach of many people, as you know. And of course, as work by actors like FIDA and others has revealed that, it is even much worse for more marginalized groups like, persons with disabilities. All right. So we have that enduring need to then, keep providing pro bono legal services. But also then, those of us who are involved in NGO programming to, work towards promoting digital literacy through training of marginalized groups and also sensitization of communities on cyber rights and how to guard against violation of those rights, right? And that can best be done, yes, by ourselves, but also acknowledging our limitations. For instance, in terms of the tech-related tools, it can best be done with the help of other actors. So we need partnerships to work together. We bring the legal, synergies, and then they come on with the technical aspects, and we guide society properly with a view to then being informed, but also equipped with the skills of protection. Those of you who are in the academia or are to be there, continuing need for research of the trends, then the challenges in regulation, or even in enforcement, like you've been mentioning in courts and through the police, personnel and the challenges that are met there. So you have got that responsibility also to now proceed with then tracking this and be able to then build on future interventions. Okay. Yes, we can also demand from government the reforms, as I said. Then we also demand for resourcing, and capacity building of personnel in institutions that are relevant to address OGBV, particularly emphasizing the need for timely justice. Right? But also data is important, as part of the trend analysis, to be able to appreciate the far we have gone, whether backwards or forward, in respect to ensuring protection of our clients. Of course, from intermediaries, we can demand both through engagement, but also through innovations such as public interest litigation for enforcement of some of these responsibilities, like proactive protection of users from OGBV. If we find that a particular actor, for instance, is notorious for being too accessible by those who violate, and without them being put to account or their content being put down, then we can put it to those intermediaries through courts of law for them to either redress or end some of the loophole. Close some of the gaps in their operations, so that then people are protected from usage, from violence that is associated with using those platforms managed by intermediaries. But also their responsibility to raise public awareness on some of their processes, procedures, and etc. So we can demand for those, and if they are not met, we can push for courts and maybe other administrative bodies to hail in on them to act as per the requirements, both under the national law, but also the best practices that have been recommended by by the international and regional frameworks that we saw earlier. In regards to protection of children and adolescents, again, our advice to clients, but also those that are under our care as children, vigilance. Yes, the law is there, but in light of the enforcement challenges, maybe we need to ensure that we are vigilant, but again, doing that in a non-invasive manner, we seek to be involved in the use of gadgets by children, get to know who they are contacting and why they are contacting them, right? Then have age-appropriate controls on some of our devices that we live with children, because they are naturally adventurous. They like to explore so many things, and if the device is accessible, it may shock you what you find them searching. They are not little humans, they are complete beings with rights and feelings, and actually are looking out to see the world and how it is, and also to explore themselves. But also then sensitizing them on digital risks and protection, and offering them support, and including reaching out to professionals for proper management in the event of breaches on their safety as children, so that they are professionally supported, with the view to then having them getting back better and to develop into full human beings with proper experiences that are far from traumatic. They need to heal to be responsible beings, so that then they don't carry on the negative experiences to the next generations after us and beyond them. So basically, I think that's what it is from me for now. And yes, there we are. I'm not sure we have some questions. Hello, Lynette. May I beg to officially sign off because I am meeting another class at in the next 15-20 minutes. So just wish everybody the best in their work, and we look forward to hearing from them on their strides in pushing this agenda forward. Thank you, and bye-bye to all.